I'm going to make this a quick video, and the topic is going to be about a product of service and how that product of service relates to strict liability, alternative liability, and general negligence. In the aspect, I want to talk about this because it has everything to do with cop watching. It has everything to do with a civil litigation. If you find yourself in the position that you have to represent yourself because you can't find a lawyer to take your case, you can't find anybody to represent you in the matter, and it's clear that you have a case. It's funny how they pull these things off and they act like their service isn't a product, but yet on the side of their car it says to protect and serve. The service is so-called protection and safety. And we all know that police protection and safety is a crock of shit. We know that. You know that. I know that. And there's nothing safe about the environment in general. I mean, none of us truly feel safe when the cops get behind us and we're going down the road, and the cops, are likely to pull you over, cite you, or find some reason to escalate the problem and issue their service to you. It might not be the service you was looking for, but hey, it was their product and it was their service. So ultimately what I'm trying to say is when your rights are interfered with, they're interfering with your products. Your products are also your rights. Your rights are, inalienable, can't be taken without just compensation or due process. In a criminal matter, it may be called due process. Due process, in a sense, only has to say in criminal matter that you are entitled to representation when you find yourself in a criminal court. In civil court, they don't afford you that same guarantee, yet you can go out and search for a lawyer and maybe find one, or you thought you found one and they misrepresented and misled you the whole way through. You see, I want to tell you also that filing lawsuits are not easy. I found this out the hard way, and I haven't lost yet. But I've came to an educational understanding that many of you will find troubling if you really understood it. The troubling aspect is it's in a huge conflict of interest. For instance, give me the driver's license that the state issued you to the state officer for the state's officer approval of his own driver's license. But anyway, the conflict of interest is huge. And moving on, I have right here on the screen, we got what is alternative liability and torts. If you don't know what a tort is a lawsuit. A lawsuit is something that you may or may not carry out as a result of your injury. You may have been injured in an auto accident or some other kind of injury that you sustained. Moving forward from those injuries, you're going to find out things in a civil claim that you're going to have to write up, especially if you don't have a lawyer to write it for you, right? So check it out. I'm going to play this for you right here. I got this understanding here.
What does 1101 mean in previous?
Let's get up here. Found this little.
What is an example of duty of
entirely on the
care?
subject.
Hitch two or more defendants will be liable if they're when two or more parties are joined. What is true? What is alternative liability in torts? By Perrine Julian / June 16, 2019. The alternative liability doctrine allows a plaintiff to shift the burden of causation to multiple defendants to prove they did not cause the harm, where the plaintiff can prove 1. That all of the defendants acted negligently and harm resulted, 2. That all possible tortfeasors have been named as defendants, and what is true when two parties are held jointly and severally liable? When two or more parties are jointly and severally liable for a tortious act, each party is independently liable for the full extent of the injury stemming from the tortious act. This concept of choosing the defendants from whom to collect damages is called the law of indivisible injury. What is the doctrine of alternative danger? Alternate danger doctrine, Jones v. This is also called as the dilemma principle. Such a situation arises when the plaintiff, P, is put in a position of imminent personal danger by the wrongdoing of the defendant. In order to avoid the danger, P suffers injury. In such cases, D is liable. What is several liability tort? Several liability refers to a type of liability system that courts use to allocate responsibility for damages in tort cases with multiple negligent parties. The plaintiff can only receive the damages actually incurred and could not get $100,000 from each defendant.
Check this out. The damage. You're riding your bicycle and you get hit from behind by a driver of an emergency vehicle who is not using his lights and sirens at the time of the accident. The fact that he failed to use his lights and sirens, he failed to give warning, reasonable warning. That warning comes as a standard requirement, that is to say that the warning is a standard of care. And the standard of care is, you will see as this goes on, is required to be rendered. So a part of that standard of care would be to use this lights and sirens. Number one, lights and sirens.
Defendant. What is the difference between joint liability and joint and several liability? With joint liability, creditors may sue once for any debt. Joint liability is essentially the opposite of several liability, in which all parties are responsible for their individual obligations only. What is substantial liability? An individual who commits a tort. Substantial factor rule, the principle by which two or more defendants will be liable if their joint actions caused the plaintiff's harm, but their individual actions alone would have resulted in the same harm. What is an example of joint and several liability?
I'll give you an example. Joint and several liability, the sheriffs operating a motor vehicle, not using their lights and sirens when required to do so, and traveling on the wrong side of the road, strikes you from behind a plaintiff on a bicycle and didn't use his lights and warning signs or none of the such. Then you immediately, after seeing a doctor, you go obtain a lawyer the very next day. And that lawyer later withdraws his contract without a show of good cause. Why would he do such a thing? Especially if it's caught on camera. So that lawyer is now a tortfeasor because the lawyer has participated in the protection as an officer of the court on the behalf of another officer of the court. You get it? Officer of the court.
Liability. For example, two drunk drivers are racing down the road and one of the drivers hit a pedestrian. The two drunk drivers would most likely be held jointly and severally liable for hurting the pedestrian because both of their actions caused the accident. Read more. What happened Billy Sunday? What are the consequences of joint liability? In law, joint and several liability makes all parties in a suit responsible for damages up to the entire amount awarded. That is, if one party is unable to pay, the others named must pay more than their share. How do you establish joint and several liability? For joint and several liability to apply, at least two parties must have acted negligently, and each party's negligence or actions must have contributed to the injury. Then the parties at fault, or tortfeasors, may be held jointly and severally liable. What is nuisance tort? So we can define the tort of nuisance as an act which gives rise to unlawful, unwarranted, or unseasonable annoyance or discomfort to the plaintiff and which results in damage to the property of the plaintiff or interfere with his use and enjoyment of his land. What is nuisance and negligence?
The difference.
If the act or omission on the part of the defendant is intentional, it classifies as a nuisance, but if it is not intentional and causes annoyance because of lack of proper care, it classifies as negligence under the tort law.
Under the tort law.
What is the difference between tort and crime? A crime is wrongdoing which hampers the social order of the society we live in. A tort is wrongdoing which hampers the individual or his property. Crime happens mostly intentionally. It is a deliberate act which people do to get some unlawful benefits. When there will be solidary liability. A liability is solidary only when the obligation expressly so states, when the law so provides, or when the nature of the obligation so requires. In this regard, Article 1207 of the Civil Code provides, Art. 1207. Read more. What was Scotland like in the 19th century? What is severally liable? In a contractual situation where two or more persons are responsible for the same performance and default on their obligations, a non-defaulting party may hold any and all parties liable for damages resulting from the breach of performance. What is the difference between jointly and severally? Jointly means that both parties have joint liability, giving responsibility for the full amount of the obligation to each party. In contrast, however, severally means that the parties are only responsible for their share of the obligation.
For their share.
What is solidum liability? An obligation or contract is said to be solidum when each is liable for the whole, but so that a payment by one is payment for all, i.e., it is a joint and several contract. Possession is said to be in solidum when it is exclusive.
And
What does
solidum when it
jointly
is
but not
exclusive.
severally mean? Severally but not jointly. An agreement between members of an underwriting group by a new issue, severally, but not to assume
joint liability for shares left unsold by other members. What is the doctrine of alternative liability? Alternative liability is a legal doctrine that allows a plaintiff to shift the burden of proving causation of her injury to multiple defendants, even though only one of them could have been responsible.
Only one of
The
them could
typical
have been
case showing the
responsible.
principle of alternative liability in action is Summers v. What is meant by joint and several liability? When parties are said to have an agreement under joint and several liability, it means that each natural person or party is responsible for all liability. What is an example of duty of care?
Duty of care.
This duty of care only applies in areas where you rely on them. For example, a doctor would owe you a duty of care to make sure that they give you proper medical attention, but would not owe you a duty of care in other areas like taking care of your finances. Read more. What is the agri-food industry? What is the concept of strict liability? Overview. In both tort and criminal law, strict liability exists when a defendant is liable for committing an action, regardless of what his, her intent or mental state was when committing the action. In criminal law, possession crimes and statutory rape are both examples of strict liability offenses. What is joint and several liability and why is it significant?
Why?
Joint and several liability encourages plaintiffs to target deep-pocket defendants who are known or perceived to be insured or solvent. These defendants tend to be professional advisors who are fully or substantially insured. What is meant by joint liability? Explain with an example. What is joint liability? Joint liability means that there is more than one defendant for the plaintiff's injury or damage. In joint tort, each defendant is fully responsible for the entire number of damages. For example, a doctor and nurse being jointly liable for a patient's wrong medical treatment. Are partners jointly and severally liable?
Let's say that another way.
Each partner is jointly and severally liable for the partnership.
What is joint liability? Joint liability means that there is more than one defendant for the plaintiff. And a joint liability, each defendant is fully responsible for the entire number of damages. For example, a police officer and a lawyer and a judge being jointly liable for the plaintiff's wrong treatment and lack of standard of care and denial of basic due processual and procedural services. Actually, being denied equal representation despite the fact that he is outsourced by the state. That is a hell of an example of joint liability right there.
Obligations. Any partner can act on behalf of the business to create obligations that bind the business and the other partners.
That bind the business. The police officer has an obligation to the standard of care. The lawyer has an obligation to a standard of care. You're out there getting arrested for constitutionally protected rights, informing, recording, doing whatever it is you're doing with your camera out in the general public. However, they claim now that you are only exercising your rights because you intend to be a general nuisance to the public. So, alternatively, the way that we've been going about it, we've been a nuisance to the public because not everybody in the public appreciates the information that's being provided to them, especially related to their constitutional rights, because most people don't even give a shit about their constitutional rights. Me personally, I don't use the word constitutional rights anymore. Step off screen here. I'm going to pull this little basket out just to give you an example of what a lawsuit looks like. And if anybody wants to comment, I'll take some comments and questions. And yeah. Yeah, I'll show you what a lawsuit looks like, okay? That's what a lawsuit looks like, folks. Right here. What a lawsuit looks like. And a lawsuit, the lawyers, they will abuse you. They will use their words and play fucking games with you. And, man. So you got to start learning rules, like what they got going on. So I'm changing my background. Let's see here. Yeah. My bad. Thought I had everything laid out, like always. That's what the word. There we go. Like, I'm gonna hang this up here in just a second anyway, but I wanted to share this part with you guys. This felt like this is important. It goes right with it. You got, according to the California State Bar, okay? According to the California State Bar, you got lawyers as a witness. The lawyer shall not act or advocate in a trial which the lawyer is likely to be a witness unless there's 3 sections and there's 4 pages long or whatever. It's got quite a bit of information in it. But the lawyer has obtained informed consent from the client. Who is the client? That's what you got to figure out, is the client. You got Rule 1.9, duty to former clients, that a lawyer shall not knowingly represent a person in the same or substantially related matter which the lawyer formerly was associated or had previously represented a client. Like, for instance, you're a judge now, and let me see if I can get all the way on the screen here. Which way does it go? This way? All right. Formerly, as a judge, you were a prosecutor, and you prosecuted cases on the behalf of the state. Now, as a judge, you are never going to rule against any previous ruling that you made against the state. So, you are a favorable judge to a defense attorney who represents the county of Los Angeles. I'm going to be real careful here because this is treading easy waters. So, the judge, formerly a prosecutor, goes on to become the judge, and then he is not elected, he is appointed, and then wins the election by the fact that nobody else actually claimed the position. So he was favorably picked by the county and put in place. So now a lawsuit comes up and they say, hey, check it out. Let me see that case right there. Let me take that off your docket. Then he runs with your case all along the side. That right there would be a participation in a formal matter, because he may or may not have prosecuted someone before for riding his bicycle on the wrong side of the road, or any number of criminal related matters on the behalf of the government. Government, and that's what they are, just a bunch of governments. Yeah, I just thought I'd share some of this stuff with you because, you don't see me much because this is where I got my nose at. And, it's really no fair for me to try to share it with you or not share it with you, because you deserve to know as much as I do. Anyway, questions, comments? Anybody want to know what's up before I hang it up? I guess not. So, hope you learned something from this video. Hopefully you found out a little bit of information. Peace out.